Madam Chair, Senators of the Judiciary Committee, my name is Derek Sherwood, and I'm here to testify in full support of Senate Bill 2383. I would like to discuss family law. I am here today in support of this bill because it is a much-needed change for the state of North Dakota. This bill is needed because our current laws force parents into a competition for custody for minor children simply by utilizing one word: best. For example, let's say today we are here to determine who is the best senator. Senator A may believe, we'll go with that one. Senator A may believe that they are the best because they have a vast experience in the legislature. Senator B may believe that they are the best because they have fresh new ideas. Now prove to me who is the best. What happened here is we created an unnecessary competition. The fact is that while this hypothetical situation is not real, this is what happens in our family courts across the state of North Dakota. As senators, you all come into session on equal ground simply by holding the title of senator and being duly elected to your position. No voice is less powerful than the other, and all votes are the same. In family court, you are required to prove to a judge in a child custody case that you are better than the other parent. We need a standard in this state that to place every individual, to include the children, on equal ground under the law. While the Constitution of the United States grants equal protection under the law, this standard is widely ignored in divorce cases simply because it is a civil, not a criminal action. Troxel versus Granville and other United States Supreme Court decisions have made it clear that parenting is a fundamental right guaranteed by the 14th Amendment for example, to exercise care, custody, and control of their children. Also, it is a First Amendment right, the right to familiar association. For example, private speech, to do homework together, to pray together, and lead by example on a regular basis. This also means this right is further protected under Article 1 of the North Dakota Constitution. It now begs the question, how is a parent able to parent when the court allows the children to move 1,500 miles away from parent A and only granting parent A 15% of the year to have time with the children, while parent B, being the custodial parent, is granted 85% of the year and has the authority to determine when parent A can exercise their parenting time? With those numbers, parent A is nothing more than a visitor. This is exactly what happened in my divorce case. Simply due to my job that required me to move here, a district judge determined there is no community support and therefore the children will be allowed to move to a place where they never lived. Senate Bill 2383 corrects these issues by establishing the rights of all parties involved to include the children and mandating that each parent is fit unless has been deemed unfit. This determination of fitness and equal protection aligns North Dakota with the Troxel standard. Additionally, this bill corrects vague language within the best interest factors. Specifically, this eliminates the moral fitness clause, commonly referred to as Factor F. State of North Dakota versus Halbach states vague laws may trap the innocent because they fail to provide adequate warning of what conduct is prohibited, and they may result in arbitrary and discriminatory application because a vague law delegates basic policy matters to those who apply the law, allowing the law to be applied on an ad hoc and subjective basis. The vagueness of this factor is morality. What is defined as moral? As Senator from this state said, it is not the job of the government to regulate morality. Yet the regulation of this morality is codified in our law. This codification allows a judge who may not agree with a person's belief to be determined immoral and not be awarded custody of their children, when that person's morals and ethics have no effect on the parent's ability to raise a child simply because a judge has a different opinion. Furthermore, this action reins in the unchecked power of the courts that have been legislating from the bench. In 2021, the North Dakota Supreme Court explained the word necessary in Slappy versus Slappy. I emphasize that the court expanded the requirement for a modification of custody to demonstrate a change in circumstance that adversely affected the child's best interest, and that change is required to include circumstances where there has been a general decline in the condition of the child. Therefore, the court, again, emphasizing the court, made it clear that simply by proving your circumstances as a party is not sufficient to modify custody or parenting time. Neither will a general decline of the primary parent's circumstances. None of this is written into the law. By doing this, the court has usurped the power of the legislative body. Senate Bill 2383 will ensure that the courts are bound by an equality standard, not an equitable one. Equality and equitability are two completely different things. Also, if passed, this bill will update our standards in North Dakota to a modern-day standard that takes into consideration the elevated divorce and children born out of wedlock statistics. While it is understood and agreed that the family unit is the cornerstone to our great country and state, we must face a fact that 50% of all marriages end in divorce, and most divorces occur within the first 5 years and the 15th to 20th years of marriage. According to these statistics, also 65% of the children are born within the first 5 years of marriage. These statistics also do not include the 40% of children who are born out of wedlock, and half of these occurring within cohabitating. The dynamics show that children are more than likely to be involved with a divorce-type custody arrangement at some point in their life. By ensuring that parents are fit unless deemed unfit, we can place children in a more dynamic home life situation where they can be raised by both parents equally under the law. Lastly, this bill protects our military members across the state. Provisions listed in Section 5, Number 3 allow a military member who is deployed to make up lost time, especially if they are inherently unable to execute parenting time due to military service. We must consider that 80% of all military marriages end in divorce, with only 0.04% of the military member retaining primary custody. By granting equal division of the time, or at minimum 100 days a year, or approximately 30%, it will ensure proper parenting time is guaranteed for our service members unless they are deemed unfit. In conclusion, for the above listed reasons, now is the time to pass this bill. We will only make the state of North Dakota better by aligning us with current guidance, update us to a modern day standard, and protect our service members. Not only will it make better for parents, but the future of the state of North Dakota, which is the children. I thank you all for hearing this testimony, and respectfully request that you vote a do pass recommendation for this bill. And at this time, I will open myself for any questions at this point.
You mentioned under military duty, you mentioned 100 days. Where is that spelled out in the bill?
If you, I can pull the bill up for you. It's in Section 5. I believe I testified in Section 5, Number 3.
Right. I don't see anything about 100 days or anything.
Okay, that would be a different portion of the bill. If we look at a minimum 100 days a year, that would be under Section 3, nope, sorry, 4. There was a portion in there regarding a minimum 100 days a year. I'm sorry, I can't find it right now on the spot, but it is in, I do know for a fact that is in there.
It's in the bill somewhere, all right. Any questions for Mr. Sherwood?
Madam Chair,
Senator Bromberger?
I just found it. It's on page 5, line 19 through 24.
Okay, I see it. At least 100 days per year. Thank you. Any questions for Mr. Sherwood? Thank you, sir.
Thank you.
Any other testimony in support of 2383?